Learning from real-world legal scenarios. One of the most powerful ways to understand property management law is through real-world legal questions, the kind that brokers and property managers actually call into legal hotlines to ask. These are not theoretical situations. These are real problems happening in Arizona every single day, and how you respond in these moments is what separates a compliant broker from one facing a violation. Most issues are not caused by lack of knowledge, but by decisions made under pressure without fully understanding the legal consequences. This section is designed to walk you through real scenarios so you can recognize risk, apply the law, and respond correctly in real time. When the owner dies, what happens next? One of the most overlooked situations in property management is what happens when a property owner passes away. A property management employment agreement is considered a personal services contract, which means it terminates upon the death of the owner. At that moment, the property manager no longer has authority to continue managing the property under that agreement. The correct next step is to immediately contact the personal representative of the estate and transfer all relevant documents, including leases, keys, and records. For example, if you are managing a rental in Chandler and receive notice that the owner has passed, you cannot continue collecting rent or making decisions as if nothing has changed. Your authority now flows through the estate, and failing to recognize this can lead to serious legal consequences. This directly connects to ARS, paragraph 32-2173, which governs the handling of documents and responsibilities upon termination of a management agreement. Do you need a license to manage property? Absolutely. This is one of the most common misconceptions in property management. Some individuals believe they can manage properties informally, especially if it is for a single owner or a small portfolio. However, Arizona law is very clear. If you are managing property for another person and receiving compensation, you must be licensed as a real estate broker. This includes activities such as leasing, advertising, collecting rent, and negotiating rental agreements. For example, a small company managing multiple apartment units for one owner in Mesa is still performing licensed real estate activity. Without a license, this becomes a violation of Arizona law. This is a major area where brokers must educate both clients and unlicensed assistants to avoid crossing legal boundaries. Record-keeping requirements: what you must keep and for how long. Record-keeping is one of the most misunderstood compliance areas. Many property managers believe they must keep records forever, while others fail to keep them long enough. Under ARS, paragraph 32-2175, property managers are required to maintain financial records for at least 3 years. This includes bank statements, receipts, invoices, ledgers, and all documentation related to financial transactions. For example, if a landlord demands 5 years of repair receipts, the property manager is only legally required to provide 3 years of records. However, failing to produce those 3 years can result in compliance issues. Strong record-keeping systems protect the broker in disputes, audits, and legal challenges. Marijuana in a rental property, a real legal gray area. This is a situation that has become more common in recent years. If a property manager discovers that a tenant is growing marijuana inside a rental property, the first step is to immediately notify the landlord. From there, the situation becomes more complex. If the tenant is not legally authorized, this may be considered drug-related criminal activity, which can justify immediate lease termination and eviction under Arizona law. However, even if the tenant is a legal cardholder, Arizona statutes do not necessarily protect the act of cultivation within a rental property. This means eviction may still be an option depending on the circumstances. For example, a tenant in Scottsdale growing marijuana plants inside the home could still be in violation of the lease, even if they hold a valid card. This is where brokers must advise landlords carefully and often recommend legal counsel due to the complexity of the law. Security deposits. After termination. What happens to the money? When a property management agreement is terminated, one of the most sensitive issues is the handling of tenant security deposits. The law is very clear. Refundable tenant deposits must be transferred to the owner after proper notice is given to the tenant. Even if the property manager disagrees with how the owner may handle those funds, the contractual obligation remains. For example, if an owner in Gilbert terminates a management agreement and demands the deposits, the broker must follow the agreement and transfer those funds appropriately. This is a great example of where personal opinion does not override legal and contractual obligations. Why these scenarios matter in the real world. Each of these scenarios highlights a key principle in property management. Your authority is always defined by law and contract, not by convenience or assumption. These are the exact types of issues that lead to complaints, audits, and disciplinary action when handled incorrectly. The brokers who succeed long-term are not the ones who avoid problems, but the ones who know exactly how to respond when problems arise. How this section connects forward. This section brings everything together in a practical way. You have learned the laws, the agreements, and the systems. Now you are seeing how they apply in real life. As we move forward into the final portion of this course, everything comes back to one central idea: broker supervision, decision-making, and risk management in real-world situations. Online discussion. Why does a property management agreement terminate upon the owner's death? Answer: because it is considered a personal services contract, and authority cannot continue without a new agreement through the estate. Why must a property manager be licensed when managing property for compensation? Answer: because Arizona law defines leasing, rent collection, and property management activities as licensed real estate activities. Why is it important to follow contract terms when handling security deposits after termination? Answer: because the agreement legally binds the broker, and failure to comply can result in violations and legal liability.